So in Texas, there are 3 kinds of field sobriety tests that are allowed to be used in court. The first is the one-leg stand, the second is the walk and turn, and the third is the horizontal gaze nystagmus test. That's the pen test like that, right? And so in each of those tests, the police officers are looking for different things. The trick here is that they're not always looking for the things that you think they're looking for, right? So you may think, are they watching that I do a straight line? And they are, but they're also watching, did you start on time? Did you stop on time? Are you following all the little directions? You know, at the end of the walk and turn, they ask you to make a circle with your feet. I have never seen somebody do it correctly because it's so complicated, the instructions. So as a defense attorney, we're coming in there and we're trying to point out the idea that these tests are designed to fail, right? So they're telling you, hey, do a one-leg stand, right? But what they're really watching for is, are you swaying back and forth? Not necessarily are you even following the instructions. The tests are so tricky. And again, the big thing is they've got nothing to do with driving. There are so many people, older people with sports injuries that could not pass the test regardless of they were sober or they're intoxicated. So again, you're not required to take the tests. If you decide to take them, we're going to attack both the instructions that the officer gave and the fact that these things are in fact designed to fail. Field sobriety tests are only as good as the instructions that are given by the officers. Some officers do the right thing and they kind of read the instructions from a little sheet of paper that they're given, but other officers kind of wing it, right? And they try to remember the instructions from memory, and they almost always make a mistake, right? And if you make a mistake in the instructions, then you can't expect that the person's going to do the test perfectly. And so that's an area that we've had a lot of success in challenging in court. So with field sobriety tests, the police officers are going to have their body cams on. The good ones will actually kind of unhook their body cam and point it at you while you're doing the test. So that usually gives us a really good avenue to look at and see whether or not you actually did fail it or whether or not you passed and the police officer just said, you know what, I don't think he passed. It also allows us to really double check the instructions that were given to you, because a lot of times officers kind of wing the instructions and they get them wrong because they're doing them all day and they think they have them memorized. And then those little instructions, they get confusing and then they cause you to get confused. And it's not that you failed the test, it's just kind of you were confused about what the officer really wanted you to do. Don't minimize the impact of being nervous as well, being scared. It's the middle of the night. All those things kind of play into this idea that the field sobriety tests, they're not actually as accurate as people think. So for years, when you were pulled over for a DWI, the officers would give you 2 different breathalyzers. They would give you the breathalyzer on the side of the road, and then they would give you a second breathalyzer at the police station. And the trick was that the breathalyzer that they gave you on the side of the road was so inaccurate that it was not allowed to be introduced as evidence in your case. And so they would just use that one to decide whether or not to arrest you, but they actually couldn't use it against you in court. The breathalyzer, the one at the police station, that one was credible enough that they could use it against you in court. The issues came up in that there's such a long period of time at times between when you take that first breathalyzer that's inadmissible and the real one at the police station. So what a lot of police officers are doing now is opting for blood. And so they'll bring a nurse in and they'll take a blood draw from you. You won't know the results immediately, but that's how they're kind of proving DWIs these days. The most common way we get DWIs dismissed is by attacking the probable cause the officer had when he pulled you over. So police officers are not allowed to just randomly pull over people and start investigating them for DWI. They actually have to have a legitimate reason. And a lot of times officers actually don't. And so they'll say things like the car was swerving or they didn't have their blinker on. And then we'll go and we'll review the dash cam footage from that night. It'll very clearly show that you were not swerving. It'll very clearly show that you did have your blinker on. And in those situations, we're able to attack the probable cause for the arrest from the inception. Everything after that goes away, right? That's the most common way that we get DWIs dismissed, is attacking the probable cause for the traffic stop. The way we attack probable cause is by filing a motion to suppress. And the idea here is that we are suppressing everything that happened after the illegal arrest. By suppressing it, it means that it does not come into evidence. It can't be used against you, right? Because those constitutional protections are so strong and they happen at the inception of the arrest. If the arrest is not valid, it doesn't matter what happened afterwards. All that matters is the arrest was not valid. Everything else is suppressed. It doesn't come into evidence. More than likely, your DWI case would get dismissed regardless of any of the factors after the arrest. Witnesses can play a really important role in a DWI defense. We recently had a case where our client was pulled over for DWI, and the police, in order to help prove intoxication, actually went to the bar that he had been drinking at that night and got the receipts. And the receipts showed that he had bought 8 beers that night. And so at trial, the prosecutor has the receipt there, and they've got it blown up on this big sheet of paper, and they're showing the jury, hey, look, he bought 8 beers that night. He must have been intoxicated. But what we did is we actually went to the bar and we talked to the actual bartender. And what the bartender told us was that, no, he had not drank 8 beers. He had drank 1 beer. But he had lost a bet with some buddies, and he owed everybody a bunch of beers. So he was buying beers all night for his friends and then running his credit card for it. So we had her go into court and testify, look, he did not drink 8 beers. He drank 1 beer. I saw him. He was not intoxicated. People forget that those witnesses can really play a role in helping craft your criminal defense on DWI. So when you're developing your DWI defense with your attorney, don't overlook witnesses. A lot of times people are leaving parties or they're leaving bars or restaurants. There are often witnesses there that can say, no, the person was not intoxicated. They weren't drinking all night. They were fine when they left. I wouldn't have let him leave if I thought he was intoxicated. And those witnesses can come to court and really help establish a good DWI defense. DWIs are often an opinion-based crime, okay? It's based on an officer's opinion as to whether or not you were okay to drive or not, okay? Because it's an opinion-based crime, there's a lot a good DWI attorney can do to help craft defense. It includes getting witnesses, it includes talking to people who saw you that night, and all those things are gonna help your case and help get you a really good outcome on that case, whether it's dismissal or whether it's something that allows you to have the DWI removed from your record at a later date.